Abusianfoɔ ne adɔfoɔ a mo nyinaa kɔ aba biom Alpha One senior sɛ wɔn subscribe ne bɔ mmɔden sɛ bɛ subscribe ne bi nneɛma ahodoɔ a ɛden a ɛkɔ so wɔ Ghana no baako mpo ɛnyɛ de ɛmpa wo ti so benya akonya ahodoɔ na etie na so ayɛ de wɔn ho deɛ ɔbɛyɛ yɛnsɛ bɛdeɛ yɛmfie ne nkyɛm ne yɛnka de wɔn nkyɛm ɛyɛ nneɛma a ɛkɔ so between Supreme Court and Parliament no. And I just say, yeah, Baba discussing na sabredi and go as Kesi pana ka go for damage just enya simple. First of all, you can kuti the reason why Bagbin one man lawyer and tenasi and I say one when you representative or Supreme Court no and they sorry and cover break cause I Bagbin we Johnny or no judge say case no lose will Johnny afinimarking in some basana man for the air can. Na as you speak no information bench say obi no bitima force Bagbin obi aso no bitima force ane ne lawyer and be information free hoba no say obi no bitima force no so man betino Supreme Court and enra eniema na ekoso no enno say case we na attorney general sorry the two court Supreme Court for ni anim say Bagbin man a lawyer and also no ankasa ban say unrespected the court, unrespected the Supreme Court. A ho and a Supreme Court judge back a catch and say, wow, only in the case, no. What one nipa no ba find out the reason why one man. What one can no unrespected giant and small giants. So won't mean find out a giant case in my own betcha say unrespected court and also unrespected court actually been in mass war. It is sabi ba ko the reason why speaker anko anaso ama any lawyer anko for that and also no senior lawyer ba be go attorney general ni mas power case attorney general unsua de yenko.
So that's the Chief Justice there. Dennis Wadam has been monitoring the events earlier in court today. And Dennis, with the absence of the speaker's lawyers at today's hearing, is there any effect or any consequential impact on the speaker's position on this matter, the fact that his lawyers were not in court today?
Well, really, Alfred, this is a matter of choice. And when you look at the rules that govern the Supreme Court itself as to this particular matter, the rules are clear as to what happens if a defendant in a case does not file a statement of case. But let's track a bit and go back to last week when the speaker himself was in Parliament. He had filed an application to set aside or to vacate the Supreme Court's own ruling. After all was said and done, they had to put the house in order so that they can have the substantive case heard, which was today. The court was of the view that it had given them, the parties, the opportunity to file their statement of case, and then they had set today for judgment. That was the initial plan of the court. However, the Attorney General was of the view that he wanted to make oral arguments today. So the court then said, okay, if that is the case, they should come today, have the oral arguments if they wanted to, and thereafter the House would retire and then give a judgment. So that was how come many were looking forward to the judgment today.
Right.
However, it turned out that the Speaker of Parliament did not file a statement of case and they were not in court. So when you look at the rules, I refer to Rule 48 of the Supreme Court Rules, CI 16, that particular provision says that it's on appearance and statement of defense, that a defendant upon whom a writ and statement of the plaintiff's case are served shall, if he so wishes to contest the case, within 14 days of the service of the statement of the plaintiff's case, or within such time as the court, upon terms may direct, file a statement of the defendant's case, which shall be signed by the defendant or his counsel. Now, what is of emphasis here is the fact that if he so wishes to contest the case, so it's the contemplation of the law itself that there are instances where the defendants
will decide
elect not to
contest the case.
And in such an instance, you do not expect a defendant who does not file a statement of case to be in court. So, the speaker not being in court clearly is an indication that they do not intend to contest this particular matter. And of course, the rules allow the court to proceed without them. And that was basically what we saw play out in court today.
I see. So fundamentally, there is no injury to the speaker's position or the speaker's case in this matter, even though his lawyers were not in court.
Well, so even if there's an injury, that is what he has elected to do. The only thing is we do not know on record why the speaker was not in court.
Well, Martin Pembo is going to be joining us on Zoom in a bit.
Yes, but that wasn't told to the court why they were not in court. I mean, it was clear that that's how come you would hear from one of the justices on the bench say to the Attorney General that he would expect the Attorney General to place a call to the lawyer of the plaintiff, to the lawyer of the Speaker of Parliament to find out why he's not in court, rather than going to the conclusion that it is disrespectful to the court. So really, the point just needs to be made that there are instances where you would have a defendant who elects not to file a statement of case in a particular matter. And mind you, even in the LGBT case, the Attorney General himself was in court. He was given an extension of time to file a statement of case. It means that there are instances where even when the time for you to file a statement of the case elapses, either by an application or the court by itself can give you an extension, or the party can pray for that extension to file a statement of case. So really, that's how come the court was able to proceed even without the Speaker of Parliament.
I see. Now let's hear from the Attorney General on this matter, because he held in court earlier today that the absence of, and then it's important that you put emphasis on the fact that it is indeed within the right of a party in a case in court to, as it were, contest their position or their case in the court of law. The Attorney General was of the view that the absence of the Speaker's lawyers amounted to disrespect of the courts. Now, this is Godfrey Yeboah-Dame, Attorney General, earlier today in court. Take a look.
Of course, being entirely the prerogative of the first defendant to file anything at all. Respectfully, I think that if the first defendant came before the court at last agenda, represented by counsel made representations before the court to file service at a certain point in time, elects not to do so, and then for no reason at all, elects also not to appear before the court. Clearly, that is disrespect to the court. I made this observation because I'm the Attorney General, leader of the bar, and all that. Such conduct, with all respect, should not be tolerated by the court.
Leave it to us, Mr. Attorney General. Leave it to us. I would rather advise that as a member of the bar for which you are the leader, you should reach out to him at the close of these proceedings to find out if everything is all right.
Well, so that's the justices there. In fact, that was Justice Amadou Tanko, yes, indicating that the Attorney General should leave that matter to them as to whether it amounted to disrespect or not, right? But let's bring in Martin Pebo.
The reason why Bagbin the anko anaso amano lawyer the anko G.Dame amano Supreme Court during the ruling just in ekoso enrano just bibia just any choice obedient mean force and pay the law and as the constitution obedient mean force Bagbin such in na Supreme Court just say you read with the constitution in ehudi no. After that, Attorney General case are ordered to Bagbin in his lawyer no so our say Oman bano say Oman respect the court, Supreme Court no. Yin when gwasi kano no. Ni we ngo ti Martin Pebo our say Attorney General wonsuan die wama politics just say agility emrane da okra no kind fufu or just say wonsuan die just we gonna nimasi pa was this the time I start Attorney General tenasi because the see any no or ma ne credibility grade that Attorney General so cramp about for my office number from to be a man in the pa young quinquity a Martin.
A legal practitioner, one of the foremost human rights lawyers we have in this country. Counsel, good evening. Thank you for joining us here on Ghana Tonight.
Good evening, Mr. Kesi.
Great. Now, and I start off from that point that Dennis just ended about the Attorney General's position that the absence of the lawyers of the Speaker in court today amounted to the disrespect of the courts, well, Justice Amadou Tanko, sought to draw his attention to the fact that it is for them to determine whether it was disrespect or not. But how does that strike you?
Well, what Justice Amadou Tanko said was the right thing. That was the right thing. I don't know if you played back. There was another part where he asked the Attorney General if he had reached out to Tadosori, lawyer for the Speaker, right? Once Tadosori wasn't present, with the fact that he wasn't present cannot lead to a conclusion that his absence there was willful, etc. So the best thing to do is to find out. So it's good that Justice Amadou Tanko drew Godfrey Dame's attention to that option, that if you don't see your learned friend, you should be able to reach out. I know Tadosori has a huge reputation at the bar. He's one of our best. So generally, you don't find adverse comments about him like that. So it's good that Justice Tanko drew his attention that you have to ask about his welfare, ask about his whereabouts. Don't just stand there and start making comments. As for Godfrey Dame, he's not learning. You see, he's not learning that this is side comments are becoming one too many. You see, at the last sitting of the court, all the submissions he made, the Supreme Court just ignored them. Yeah, so he has to learn that, listen, there are times that you have to be gracious. If the man hasn't come, don't go on and on and on about him. No, it's not the best. You see, the last time, on the 30th of October, all the arguments he made, you see, the court didn't dignify him with a response. So Godfrey Dame needs to learn that it's not everything you need to comment about. No, it's not everything you have to comment.
Today, there was one point that he made that, in fact, that emphatic statement that, in his view, Speaker Michael Quay's ruling on the Fomena case was illegal. It was unconstitutional, and so cannot form a basis for any decision forthwith.
Oh, obviously, it's in his favor, or it's convenient for him to make that comment today. Because if you were to say Okwe got it right, what it would mean is that then this case would follow the same pattern. That is to say, they would lose this case of the vacation of the 4 seats by the various MPs. So it's convenient for the MPP and for Godfrey Dame to say that Okwe got it wrong, so that Okwe's ruling does not come back to, hound or bite them. That's just it, really.
I see. But on the bit about how that also gives pointers of really how the case is going, the path the case is going to take going forward. I want us to take a listen to, and if you indulge me, we're also live on 3FM 92.7. Let's take a listen to the Attorney General making the argument that, to the extent that Parliament is constituted by a certain number of MPs elected to represent constituents through an election, it is only that election and the election process that can alter the constitution of Parliament, right? And I'll find out if that's consistent with your understanding of what the law really says. But this is the Attorney General on the constitution of Parliament. Take a look.
Insofar as Parliament is constituted by a certain number of MPs or members of Parliament representing those constituencies, the composition of Parliament shall not be altered except as prescribed for in the Constitution. So no person or authority, with all respect, has the power to make any decision at all or construe the Constitution in a way which will alter or change the composition of Parliament except as it is in the Constitution.
So, Counsel, that's the Attorney General there, that to the extent that Parliament is constituted by a certain number of MPs elected to represent constituents, the composition of Parliament shall not be altered except as prescribed by the Constitution.
You see, this is tautologous, right?
This is what?
Or let's say security. We are going around in circles, actually, instead of the tautology. It's going around in circles. The security is that the Constitution has prescribed in Article 97 clause 1, how a member of parliament will lose his seat. And it's very clear in G that if you are an independent, H, let's start with H, this is a CMS case. If you're an independent member of parliament and you join a political party, ipso facto, you lose your seat. So, Mr. Kansi, as we are talking, isn't it an indisputable fact that Isiama has joined the MPP?
Yes, it is.
Isn't it?
It is. It is a fact.
Yeah. So that's it. Straight. Pro tanto. Ipso facto. Just by that very fact alone. Isiama will lose his seat in this parliament. It's not by any future parliament. The Article 97 is not talking about future parliament. Then you go to the other parliamentarians. 91, why do I say 91? 97 plus 1 G. Okay? It says if you're a member of a political party and then you seek to become independent and remain in parliament. As we speak now, the MPP constitution is very clear that if they fill the candidate for parliamentary elections and you, an MPP member, also seek to contest that election, you automatically, and I'm emphasizing automatically, lose your membership. That's Article 3 plus 9. Yeah, 3 plus 9. I'm sure, Mr. Kansi, you've read it in the past.
Yes, indeed.
So, Mamle, Kwejo Asante, MP for Sum, Peter Kwachiaka, that's MP Amefi Central, he's NDC. And then the third one.
That is, that's the former member of parliament who is now contesting on the ticket of the MPP.
Yes, we've dealt with this already. So these three, Kwejo Asante, Mamle, and then Peter Kwachiaka, they were members of political parties, and now they filed as independents. So we are clear that the MPP constitution says if you file as an independent to contest an MPP member, you automatically forfeit your seat. So that's it.
Right.
So I'm expecting the Supreme Court to come up with an interpretation that will give meaning to the MPP constitution. They sponsor the candidate. They sponsor the MP, and they say if you do such a thing, you automatically forfeit your seat. It makes sense because you see, political parties, all right, deal with sensitive information, etc.
Okay.
So they cannot afford to continue to have moles, open moles. Of course, some people are secret moles. But when you have an open mole in your campaign, very brazen, openly like this, no, it cannot be tolerated.
Abusanfo di ankasa yasuma niema chese koso Supreme Court ene parliament no na chese ya bobo ho the latest update chese koso nyina bro behind the scenes niema ye nim de ekobia no ye di nyina ye de abroach chese wa on subscribe no pomodian so be subscribe se na bia so no ba kumpunye de empathy so big nya update ni na so saka bia na de ama onua na no so ye de ehu de ekobia si tie Martin Pebu asema opeso chese no wanwa yi pa wanwa yi pa se mrane da ho na adikitua we ye nam ho days months ni ye nam ho saa na parliament atum na nipa ba ku menu bi by force mrane se no interpretation be no muhi o se de ben o onte ase no catch Supreme Court no mo tena case ni so nyanse. So munima omonhwe MPP for kra constitution. So munima omonhwe MPP for attorney general enia breed din bibia cheso ye dwoma MPP no se dia amanfo ka no Enya breno omonhwe NPP4 constitution. NPP4 constitution is stating clear say the moment that thing be happen, sa de that Supreme Court back and forth, Speaker Bagbin Gina so did clear a year parliament, a year for MPs for seat vacant no. Omonhwe the NPP4 a year constitution ne kakeke. Omonhwe no kwankeke. Na case no omonhwa so. NPP constitution cry say ehun hia say nipa na okofale for independent and as all free party no ehun hia so otwe letter crabre party no ehun so hia say party no so declare na say onka party no ehun hia o see the moment as action ni be take place automatically so no so emphasis on automatically. The moment that actions in the happen a just on party no we jin ho afrim just down no happen so ba we jin ho afrim. So NPP constitution na SU and NPP constitution is run a chain Ghana constitution omunye free Ghana constitution. So interpretation be say ba na se watch say anko Amiye who said the identity and Kasankasa now reflected the NPP constitution in Crampo can. This NPP constitution in Hono can this uncontrolled from. Into or a G Supreme Court say, making sure say ruling a bebano, any ruling a yin expect said the constitution actually bear a dahono, wing a proverb, I throw the paper into omunye ne inside line with a the NPP constitution in the air canon. And yes, sir. And the case for Friday as I baby. Now it's a foot to the Martin General say on conny books no go see dear no nini na dena oyen a too much or good any mass too much. Now near out of forcing back and forth no we knew now liquid use like us or good any mass too much to ontness no see dear no who say we are Attorney General for Ghana, not a political party. NPP for money attorney general, NDC for money attorney general. More Mwankasa attorney general and fire home, but we for Ghana, for so Ghana interest until now. I think same be too much. I under the comment section. Subscribe and share my news so you didn't sign behind the proceedings.